Good afternoon to all of you friends. A very good afternoon to all of you. On behalf of BYJU'S Exam Prep, the most comprehensive preparation app for all exams, I, Surajit Bhaduri, welcome each and every one of you for today's live session on Legal Aptitude, Legal Shorts Part 3. So in this very session, we are, as usual, going to discuss with you certain very important questions relating to legal knowledge. So friends, a very good afternoon to each and every one of you. Ishan Singh, Bilindya, Mansi, Ahana Datta, a very good afternoon to each and every one of you watching me live on your favorite YouTube channel. So friends, in today's session, as usual, we are going to discuss some important legal knowledge question. Now, but before that, now since you guys are preparing for CLAT 2022 as well as for CLAT 2023, it is absolutely important that you know that if you are preparing for CLAT 2022, the examination is on in the month of May. And if you are preparing for CLAT 2023, the examination is not going to happen in 2023, but it's going to happen on December 2022. So you have, those of you who are preparing for CLAT 2022, you have around 5 months left, 4.5 months left. And those of you who are preparing for CLAT 2023, you have around 12 months remaining for this particular entrance examination. So right now it is high time that you concentrate, you start your preparation well for this very important examination. Okay, so let's get going. Okay, let's get going. Without much ado, let's begin with today's session. So today we are having part 3 of legal shorts for CLAT 2022 and 2023 aspirants. BYJU'S Exam Prep brings to you a comprehensive preparation course in bilingual batch 5. In this course, you get learn in the language you understand, weekly performance test, all topics are to be covered through live classes and quizzes. And above all, there will be faculty counseling and guidance session to help you ace this particular entrance exam. So the first question is up there on your screen. Who is known as the father of public interest litigation in India? Now, who was this judge who came out with this new jurisdiction of the courts, whereby a public-spirited man can approach the High Court or the Supreme Court by filing a PIL for the cause of the poor, the downtrodden, people who cannot approach the court. So there are a lot of people who cannot themselves come to the court and ask for justice. For them, we have something called public interest litigation. The question up there on your screen is, who is known as the father of public interest litigation in India? And the correct answer is Justice P.N. Bhagwati. Justice P.N. Bhagwati is referred to as the father of public interest litigation in India. The correct answer is option A. Okay, most of you got it correct. Many congratulations to all of you who got this answer correct. Very good, very good. Okay, moving on to the next question. How many parts did the unamended Constitution of India had? How many parts? Unamended Constitution of India. Okay. So when the Constitution came into being in the year 1950, How many parts did the Constitution have? Part 3 deals with fundamental rights. Part 4 deals with directive principles of state policy. Very good. So these are certain important parts you need to remember, guys. So how many parts did the unamended Constitution of India, when the Constitution came into being, had? Later on, there were certain amendments, certain parts were inserted inside the Indian Constitution. But how many? And the correct answer is option C, 22. There were 22 parts. Okay, the unamended Constitution had 22 parts. That means when the Constitution came into being, when the Constitution of India came into being, there was only 22 parts. Okay, so the correct answer is option C. Many congratulations. So this is how these questions which you are preparing for Maharashtra CET, ALET, Jamia, and other host of examination, Symbiosis and other host of examination, they ask you these kind of questions. Okay. Question number 3. Who amongst the following is known as the father of Panchayati Raj in India? Who is known as the father of Panchayati Raj system in India? Was it Lord Ripon? Was it Mahatma Gandhi? Was it Bal Gangadhar Tilak? Or was it Balwant Rai Mehta? Which of the following? Please tell me. Now you must have heard about the Balwant Rai Mehta committee report. Now based on this committee report, Panchayati Raj system in India was introduced. Okay, so the Panchayati Raj system in India, one of the founding fathers of this ideology of the Panchayati Raj system. Now there was this Balwant Rai Mehta committee which recommended the current structure of the Panchayati Raj system in India. So the correct answer is option D, Balwant Rai Mehta. Balwant Rai Mehta, option D is the correct answer. Okay, very good. I want more and more students to join this particular session because these are very important session for each and every one of you preparing for CLAT and other lot of examination. Okay, so are you guys enjoying today's session? If you are doing it, then definitely press the like button. Okay, that's the gift that you can give it to me. Okay, and share this video with your friends and ask your friends to join this YouTube classes every day at 3:30 p.m. which I conduct on this YouTube channel. Okay, question number 4. Question number 4. Right to property is a fundamental right, constitutional right, statutory right, or both a fundamental right as well as a constitutional right? Now, right to property used to be a fundamental right, right? Right to property used to be a fundamental right. It used to be a fundamental right. Now this fundamental right was taken away by virtue of an amendment to the Indian Constitution, and today it only exists under Article 300A of the Indian Constitution. So right to property today features in Article 300A of the Indian Constitution. So it is not a fundamental right. It is not a fundamental right. It used to be a fundamental right. It is not a fundamental right today. It used to be a fundamental right. Today it is just a constitutional right. It is just a constitutional right. So the correct answer is option B. Many congratulations to each and every one of you who got it correctly. Okay. So are you guys enjoying today's session? Okay. Okay. Very good. Very good. Very good. Very good. Okay. It is not both A and B. No, 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 no. Ahana Datta, no. Neha Dubey, no. The correct answer is option B. It is only a constitutional right and not a fundamental right, because it has been taken away from part 3 of the Indian Constitution. Now keep this in your mind, that fundamental rights are those rights which are present in part 3 of the Indian Constitution. So part 3 rights are referred to as fundamental right. Right to property today does not come under part 3 of the Indian Constitution. Okay, that's good. That's good. That's good. That's good. Okay, chalo. Question number 5 is up there on your screen. Which of the following landmark Supreme Court cases is related to Bonded Labor System Abolition Act of 1976? The Bonded Labor System Abolition Act of 1976. Which landmark Supreme Court judgment relates to the Bonded Labor Abolition Act of 1976? Is it Bandhua Mukti Morcha versus Union of India? Is it MC Mehta versus State of Tamil Nadu? Is it Bachpan Bachao Andolan versus Union of India? Or it is Avinash Mehrotra versus Union of India? Which of the following is the correct answer? Which of the following cases dealt with Bonded Labor System Abolition Act of 1976? And the correct answer is, can any one of you tell me the correct answer? Fast, fast, fast. Fast, guys, fast. I'm waiting for you. I'm waiting for you. Which of the following? Okay. Bilindia says MC Mehta. No, it is not MC Mehta. It is not MC Mehta. No, Mansi, it is not MC Mehta versus State of Tamil Nadu. The correct answer is Bandhua Mukti Morcha versus Union of India. The correct answer is Bandhua Mukti Morcha versus Union of India. So the correct answer is option A. Option A is the right answer. Bandhua Mukti Morcha versus Union of India. Moving on to the next question. But before that, BYJU'S Exam Prep brings to you a comprehensive course, Batch 5, for CLAT 2022 aspirants. So those of you who are preparing for CLAT 2022, BYJU'S Exam Prep brings to you this comprehensive course, Batch 5. Now, the course has been launched. Get yourself enrolled, those of you who are really wanting to crack CLAT and other law entrance examination for the year 2022. So what do you get in this particular course? You get to build CLAT 2022 concepts from scratch for beginners, expert guidance by NLU alumni until the day of your exam, progress assessment test to gauge your performance at regular interval, and above all, highly interactive doubt clearing session so that you can ace CLAT 2022. Moving on to question number 6. The principle of strict liability. You have absolute liability and strict liability, right? So the principle of absolute liability in tort emerges from which case? Is it Ryland versus Fletcher? Is it Ashby versus White? Is it MC Mehta versus Union of India? Is it Carlyle versus Carbolic Smokeball Company? Which of the following cases laid down the principle of strict liability in law of torts in the world? Yes. So there are two types of liabilities. Okay, there is something called vicarious liability under law of torts. Master servant, principal agent, partners in a partnership firm. That's one. And thereafter you have strict liability and absolute liability, right? So the principle of strict liability emerges from which case? Is it Ryland versus Fletcher? Is it Ashby versus White? Is it MC Mehta versus Union of India? Is it Carlyle versus Carbolic Smoke Ball Company? And the correct answer is Ryland versus Fletcher. Many congratulations. Shivani Verma, Ahana Datta, Mansi Agarwal. Many congratulations. Very good, very good, very good. Okay. It is not Ashby versus White. Now, Ashby versus White dealt with that very famous case wherein a person was illegally stopped from casting his vote. And the court awarded him compensation because his legal rights were violated. So, damnum sine injuria and injuria sine damnum, right? Ashby versus White. Ryland versus Fletcher, the principle of strict liability. Then you have MC Mehta, absolute liability. So the correct answer over here is Ryland versus Fletcher. Option A is the right answer. Many congratulations to all of you who got it correct. Question number 7 is up there on your screen. Which of the following is a non-compoundable offense in India? Non-compoundable offense in India. What do you mean by non-compoundable offense? I'm not going to tell you now. I want each and every one of you, after the session is over, search in the internet and tell me the answer in the next class. What is non-compoundable offense? Search it. Now, if I tell you everything, then, it doesn't, there's no point. You must also get into the habit of knowing something from your own. So what are non-compoundable offenses? Let's see. Okay, that's a homework for you. Okay, is it criminal trespass, mischief, defamation or sedition? And the correct answer is sedition. Okay, it is a non-compoundable offense in India. Okay, sedition is a non-compoundable offense in India. Option D is the right answer. Not criminal mischief, it is compoundable. Mischief, criminal trespass is compoundable, mischief is compoundable, defamation is also compoundable offense, but not sedition. Question number 8. Let's read the question and please tell me the correct answer. In India, softwares are protected under as patents, as trademark, as copyright, or all of the above. Now, software, is it patented? Is there a trademark? Is it a copyright? Now, of course, it cannot be a trademark because a trademark is just a mark. Okay. Is it a patent or is it a copyright? The confusion should be between A and C. Okay. And the correct answer is softwares in India is protected as copyright. Okay, it is protected as copyright. Very important. Do keep this in your mind. It's a very important question. I want each and every one of you to keep this in your mind. Okay, so softwares in India are protected as copyright. Very important, very important. Okay. So guys, if you are liking today's session, definitely press the like button. Okay, I want each and every one of you to press the like button if you are liking today's session. Okay, fantastic. And definitely we will be there with you till your exam. We will help you out to the best of our knowledge and ability so that you can crack CLAT and other host of examination for the year 2022 as well as for the year 2023. Moving on to question number 9. Which factor separates robbery from dacoity? Is it time? Is it place? Is it property? Or the number of people involved in that crime? Number means number of person involved in the crime. So is it based on time, place, property, or the number of person involved in a crime? Now the correct answer is option D. Option D happens to be the right answer. Number of person involved in a crime. So robbery and dacoity, the difference is it is based on the number of people who are involved. Okay, number of person involved in the crime. Very good. So the correct answer is option D. Very good, very good, very good. Fantastic. Moving on to question number 10. Moving on to question number 10. Read the question very carefully and give me the correct answer. X files an RTI, right to information, at ONGC Corporation. Who will have to file him within 30 days? Now, you are filing a right to information application with the corporation. With whom do you file? Who is the person to whom you ask for certain information? Who is that person? Is it the head of ONGC? Is it the authorized representative of ONGC? Is it the Ministry of Petroleum and Natural Gas? Or is it the Public Information Officer of ONGC? Oil and Natural Gas Corporation. Okay. So you want to file an RTI against ONGC seeking certain information. So you have to file that thing with whom? And who? And that person is also required under the law to reply you back within a period of 30 days. Okay. So there is a public information officer, who is duty bound under the RTI Act, under the Right to Information Act, to reply to you within a period of 30 days insofar as your questions, insofar as the information that you have asked for. So if you have asked for certain information from ONGC, the Public Information Officer of ONGC is under the law. He is required under the law to reply to you within a period of 30 days. Am I clear? Have I made myself clear to each and every one? Okay. Any doubts? Did each and every one of you understood? Okay. Now these are very, very important and interesting classes which none of you should be missing if you are really planning for CLAT 2022 or CLAT 2023. Okay. Fantastic, fantastic, fantastic. Moving on. So the correct answer is option D. Friends, BYJU'S Exam Prep brings to you a comprehensive course batch 6 for CLAT 2023 aspirant. So if you are a CLAT 2023 aspirant, you have a comprehensive course from BYJU'S Exam Prep batch 6. The batches have started. Get yourself enrolled. Now, what do you get in this particular course? You get Build CLAT 2023 concepts from scratch for beginners. day-wise study plan covering the entire syllabus to help you score better, expert guidance by NLU alumni provided until the day of your exam, and 200 plus live classes based on the latest CLAT pattern along with interactive quizzes. So friends, with this, we come to the end of today's session. Thank you very, very much. God bless you. I hope you liked today's session. You understood the kind of knowledge you are supposed to have when you are preparing for a law entrance examination. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy, and definitely all the very best for your preparation. God bless you guys. See you again. Till then, bye-bye.